our life.
Everyone, thanks for joining our Friday live stream. I wanted to talk about a few different kinds of issues today, and these are all issues that my EB1A clients and my EB2 and IW clients talk about when they've already retained me and we're talking back and forth about the future. Three different topics here. We're going to talk about birthright citizenship. We're going to talk about the revocations of legal permanent resident status, and also denaturalization. These are all things I think that people more consider or come up as concerns once they've secured the I-140 approval, or even once they've secured the green card, or once they've secured citizenship. But it's important for everyone, I think, who's pre that process, so everyone who is considering EB1A and EB2 and IW, to just kind of be aware of what's going on here. With regard to birthright citizenship, there are many of you perhaps on the live stream here. There are many people that I talk with who were born outside the US, so they are immigrant workers here on H-1B, on F-1, in various statuses. But, people move to the US usually before they start a family, and then they graduate college, and then they get married here, and then of course they have children here. And those children, as long as they're born in the US, are American citizens. So you do not have to sponsor your children in many cases. They're already US citizens, and you just need to be concerned about securing your own immigrant status here in the US. A lot of people are very concerned because Trump issued this executive order saying that he would cancel birthright citizenship and replace it with some other process, which is very ill-defined. And there's been a whole legal drama with the Supreme Court involved at the last moment that has been challenging his ability to do this. In the United States, we have birthright citizenship through an amendment to the actual Constitution, which is the highest law of the land. And so birthright citizenship is a given. I think every single judge who has seen the executive order as a case before them has said immediately that this executive order is unconstitutional on its face, like the most clear constitutional violation that can exist. So ultimately, I am not concerned that your children will lose citizenship status. I am not concerned that the children of immigrants who are born in the US will not be considered US citizens. I am concerned about what the journey will look like. Like, certainly there will be some hiccups along the way. There may eventually be some passports denied or some deportation proceeding initiated. Like, some people will certainly be caught in the crossfire here. So I'm not saying that there's no risk, but in the end, the legal drama should work out just fine where birthright citizenship is upheld and the government, or the executive branch specifically, won't be able to do anything about it. A lot of people come to be concerned, and they're asking what steps they should take now, if they need to do anything for their children who are already here and who are US citizens and who are going to school here. And I'm telling people just to wait. Wait and see how the legal drama plays out. There really isn't any action that you need to take immediately right now. I would make sure your children have documentation. If they don't have a US passport already, I would definitely have them apply for a US passport. If there's any hint that a passport would be denied, or if anything strange happens, like, you should talk to a litigator who is actually litigating some of these birthright citizenship cases. But absent that kind of situation, just wait, because your children are US citizens. They're recognized by everyone except for very specific actors in the executive branch as US citizens, and they should be fine in the end. Also, the latest update on the case, there's now a national class action that's been certified, and that class action has won another injunction against the enforcement of the rule. And so the Trump administration is not legally allowed to enforce their executive order to get rid of birthright citizenship. And the way this is playing out, this is bound to go to the Supreme Court again at some point. So everyone can just breathe for right now. All the developments in this case are good, and no action is needed. So just relax. Sit tight. Things will resolve themselves. And there isn't anything you need to do unless it appears that the government is taking direct action against your children. All right, so there's that focus of the US government. That's probably the least concerning topic that we'll talk about now. There's another topic that's coming up about green card revocations. And I guess you could also lump in I-140 revocations, even though that's not as severe as a green card revocation. There's just a theme right now with the administration about revoking rights, revoking status whenever they can. It's important to know that when you become a legal permanent resident, you have a lot more rights than you do when you're on a non-immigrant visa, like on an H-1B. But it is possible to lose that status. Generally, the government can only revoke that status if they can prove that a mistake was made and less than 5 years have passed since you were granted that status, or if there was some kind of fraud or misrepresentation and you obtained lawful permanent resident status by deceiving the government and by lying about something. So it's usually a really high bar. Like revocations of lawful permanent resident status are really, really rare. But we are seeing the government try to do this a little bit more and kick people out of the country by removing their lawful permanent resident status. And then, of course, they wouldn't be able to apply for any other status. A lot of times when lawful permanent resident status is removed, the person has been accused of fraud or misrepresentation, which comes with a permanent bar on entry to the US. So people who are accused and who are going through this revocation process have a lot to lose. Like it's a really high stakes matter. So anyone who has these kinds of proceedings initiated against them should definitely get an attorney. And you do have the right to attorney representation. It's always at your own cost. The government does not provide an attorney to you in these circumstances, but you can have an attorney represent you and speak for you. And, you know, I'm concerned with the emphasis being placed on revocations, that a lot of revocations are not really based on facts, but they're based on implications in the record. I've been involved not with revocations of legal permanent resident status, but with revocations of I-140s and I-130s before. And a lot of times the government is looking at facts or implied facts that are on a previous written record, and they don't seem really willing to consider the full picture or what happened. Like they're only looking at this very discrete set of facts. And so if there's an implication of some prior fraud or misrepresentation on the record, it is really difficult to overcome that, even if you have a lot of proof that it never happened. It's hard to explain things once you're accused of fraud. It really is. So these kinds of cases can be really concerning. You definitely need an attorney representing you if this comes up. You know, that being said, I think the fact that these are happening with both I-140 revocations and then revocations to actually strip legal permanent resident status, I think it's causing a lot of panic in cases where there's nothing to panic about. Like I've had a bunch of people come to me for consultations and say, you know, I published in this journal and now this journal is seen as sketchy, but I had no idea at the time. Like, is my case going to be revoked? And reasonably, no, you are probably fine. Like the risk of revocation in that really specific scenario is really low. So you may want to know what attorney you're going to talk to if something comes through, but that's pretty much it. Like you do not need to have this hanging over your head. As long as you acted correctly and acted with integrity the whole time, you will be fine. On the other hand, if you did engage in some sketchy practices and are worried about an I-140 revocation, you know, it is a fair concern. And again, don't let it consume your life, but you should probably talk to an attorney at some point to see what steps that you can take there. There is such thing as affirmative disclosure. Like if you did something wrong and you know that it's going to come down at some point and come back to haunt you, you can discuss doing some kind of a disclosure or participating in an investigation. And that can help your case It just needs to be navigated very carefully because there's some cases where it can just really hurt as well. So talk to an attorney about that. All right, and then for denaturalization cases, I think the media is reporting on these a little bit wrong. Like every time I read an article on denaturalization, there's a missing piece to it that they're not talking about. Usually, you can only be denaturalized if you committed fraud or misrepresentation to obtain naturalization. So people are talking about how denaturalization proceedings are occurring for people who had criminal records that are 20 years ago and for minor crimes and that kind of thing. I know that's what the news is reporting on, but that can't really be the basis for the denaturalization. Like that's probably a fact that comes up in the record. The basis for the denaturalization is going to be that they hid that fact from the government. And so they achieved naturalization without making proper disclosures according to the questions that are asked on the form. So again, it's all about fraud and misrepresentation. You do need to be very careful anytime you submit a form to the government that you are accurately answering the questions to the forms, that you are making disclosures whenever you need to make disclosures, and that you're not trying to hide any kind of past criminal activity or criminal record. Having a past criminal record does not prevent you from becoming a U.S. citizen. There are certain crimes that will prevent you from becoming a U.S. citizen, like major serious crimes will definitely weigh against you. Like you can't become a citizen if you are a murderer, for example. But small crimes like marijuana possession or reckless driving or a DUI, like that kind of stuff, it's taken into consideration as far as your good moral character is concerned. But it's not a bar to becoming a U.S. citizen. It's just taken under advisement. So, if you want to become a U.S. citizen and you have some of these things on your record, sometimes the answer is just to wait so that you have more time to demonstrate your good moral character and ties to the community and all of that. Sometimes you can try for it and like really explain why this doesn't represent you anymore and why you will not be in danger of committing crimes. But you don't want to hide something, become a citizen, and then have them find out later that you hid it, because that can result in denaturalization. So like politically, the push for denaturalization is a really big deal in the United States. Myself and many other people are very concerned that it's a focus of the government. I think all of us agree that if someone obtained naturalization fraudulently, then they shouldn't be a citizen. It's just the conversation in the media is making this sound like a more political consideration than just like a pure determination of whether or not fraud occurred, which is interesting. So I'm encouraging people not to worry too much about it, but if there is something in your record that you didn't disclose and you want to talk to an attorney about it, it's probably a good time for you to do that. Because again, some things can be fixed with an affirmative disclosure. If you just made a mistake on your form, you can explain that. Some things, though, are pretty tough to fix in immigration, and you'll want to know what you're dealing with. All right. Just to dispel a rumor here, like the government can't just take away your citizenship because they don't like your political views. They may try to do that at some point, but if they do, the ACLU will definitely sue, and it will be a big national lawsuit. We do have freedom of speech here in America as U.S. citizens and even as lawful permanent residents. So, I'm not, even though I'm worried that it might happen, I'm not ultimately worried that that's going to stand as a decision. But just remember, the news headlines aren't reporting on everything, so the government can make it seem like they denaturalized someone for a political belief. Really, what's underlying that decision, though, is some kind of fraud or misrepresentation. So just keep that in mind.
I'll be right back.
Okay, yeah, no worries. I was going to open it up to questions. I don't see any questions in the chat here, but if you do have questions, feel free to go ahead and put them in the chat. I can talk just really quickly about how EB1A and EB2 and IW applicants are impacted by all of this. I can say that it's just causing a lot of anxiety and fear among a lot of applicants. And that's fair. You know, I wake up some days and I feel super anxious about the headlines and what's going on in immigration and all of that. The US legal system, though, does have a lot of built-in checks and balances. So even if there are things to be anxious or afraid of, there is ultimately a way to make your case heard, to speak to an adjudicator or a judge, or present your case in some way. And sometimes you need an attorney to help you do that. Sometimes you can just do it on your own. But it's not all doom and gloom, despite all of the headlines. You know, the process is still working very well, especially for EB-1As and EB2 and IWs. And like, I haven't noticed huge swings in adjudications so far. I will say, like, the EB2 and IW trends are terrible right now, but that has less to do with the Trump administration than it does with just like an overall shift in adjudications that happened during the end of the Biden administration and has carried on since. But there really have been no changes with regard to the EB1A. All right, we have a question from Denise, and I won't put it up on the screen here because I don't actually know how to do that. But Denise has an off-topic question. To what extent do you think having a company in the US may make an EB1A case stronger? And the answer to that is you don't need to have a company in the US. Having ties to the US certainly makes a case stronger. So if you are already here in the US and already working for a US employer, it's not necessary to have your own company. If you are outside the US and have never worked in the US, sometimes it is advantageous to set up your own US company and have that be the vehicle through which you will immediately contribute to the US with your expertise in the field. So it is pretty common for EB1A applicants who are outside the US to set up some kind of business here before they file the EB1A. Excuse me. Sometimes that's just a small consultancy business. Sometimes it's a full branch of whatever business you're operating abroad. It can help. As far as entrepreneurship is concerned, entrepreneurs don't have a built-in advantage for EB1A. I mean, if you are an entrepreneur who's been super successful and your company has really taken off, gotten a lot of funding, hired a lot of employees and all of that, maybe got some attention in the media or some acclaim for your products, you can use all of that in an EB1A. But the startup or the company here in the US has to be really, really good in order for it to factor in or matter for the EB1A. It's not enough to have a small but successful business. You need to have something flashy that you can highlight for the EB1A. All right, I'll follow that up. So continue to post questions if you have any questions. I'll follow that up and say the O1 is of a lot of interest to entrepreneurs. The O1 has a slightly lower standard than the EB1A. And people who want to set up companies in the US or go through a traditional startup process, as long as they get some traction and some significant funding and make some connections with the US market, it's much more possible to leverage that for an O1 visa than it is to leverage it for the EB1A visa. For the EB1A visa, you need a whole new level of extraordinary like operations. Or for the EB1A, most often people who are successful in showing their entrepreneurship factors into their qualifications have been doing it for a very long time and have a very, very established business. Right. For entrepreneurs in the US, so we'll go with this theme. The cases that I've worked on for I-140 revocations actually mostly come from entrepreneurs. USCIS doesn't always love like the small mom and pop business type thing in the I-140 context. I think that they do tend to scrutinize those business arrangements quite a bit as compared to people who are working for established companies in a 9-to-5 role. And I don't think that should turn you off if you are an entrepreneur from applying for the I-140. You should pursue the I-140 through your own business because it will give you maximum flexibility. But startups, like startup culture in the US tends to be very exaggerative. Like a lot of claims are made a lot of the time that just don't have any substance to them. So I think for entrepreneur cases, you need to be extra careful about how you're presenting information to USCIS. That's very, very important. All right, and then Denise asked if having a patent makes the EB1A case stronger. This is also a good question. In general, I think patents are a positive addition to the case, but whether or not they meaningfully impact the chance of approval depends on the impact of the patented technology. So it's not the patent itself that shows impact. The patent just protects the idea, but you need to show that the idea has impact and major significance out in the market. So that can mean showing that the patented technology is used in a product with huge market share. It can mean that the patent has been heavily cited, so it's influenced other researchers in the direction that they're taking. You could show that the technology is used by many different US businesses or has a certain level of economic impact in the US. You just want to be able to show a lot of facts and figures around the influence of the technology that's patented. So just having the patent is not really good enough to claim original contributions of major significance. It's not really enough for an EB1A approval, but it can be an important piece of evidence, and it's generally a positive sign and a positive indicator. All right. Jason, I just answered all of Denise's questions here.
Okay.
Anything else that you think we should address? I was talking specifically about entrepreneurship in the O1 and the EB1 context, but we have just a few minutes left here if anyone else has questions. All right. So just the takeaway, there's a lot of information out in the news. Don't despair when you read the news headlines. The news often gets the facts wrong, and they're reporting on a certain angle of what's happening. And yes, the facts they're reporting are accurate and they're true, but they're not like they're from a legal standpoint. It's not describing what is legally happening with the case. And so a lot of times news stories tend to be inaccurate if people are looking to them to see what the legal implications are. Scientists have the same kinds of qualms with media. Like anytime the media reports on any kind of scientific development, the scientists will read the article, roll their eyes and say, well, I mean, it's just not accurate. That's not what's happening. That's not really what the paper is about. That's not what the discovery is. The news media really just gives a surface level look, and it does tend to be really heavily politicized right now. So legally, I am just reassuring everyone on the call, there aren't major legal problems right now with birthright citizenship. There aren't any major changes in revocations, either of I-140s or of lawful permanent resident status. There are really not any huge changes in denaturalization. It's all a matter of like appearance and a push for certain priorities, but the legal structure of everything has maintained, and it's still the same. And everything is still based on fraud. So it takes some encouragement with that. It's not like the government's just going to strip your status all of a sudden one day for posting a meme about Donald Trump or something like that. You do still have rights. The administrative system is still working, even if priorities have shifted and even if there's some scary stuff in the media right now. All right. Thank you, everyone, for joining. Feel free to schedule a consultation if anything in this conversation like prompts you to think there's something you need to talk about with an attorney. I'm happy to talk with you. Otherwise, I will do another live stream next week. All right. Thanks, everyone.
Thanks, everyone.